weird pardon, some people would say.
Yeah.
Pardon, I mean, guys that were completely, what's that guy? He fled to Switzerland or something like that. Come on.
Well, we're talking about impaired driving, and it seems that these drunk drivers can do this over and over and over and over again.
Well, the last time the guy got busted, I think, was 2005. Okay, so he's been clean for a while. We don't know all the facts. We don't know all the facts. Well, we don't know all the facts. I mean, he could have gone to, maybe he doesn't drink anymore. Maybe he went to AA. I mean, that's why I say I don't know all the facts. So I can't make a hardcore judgment. We can only speculate about the circumstance. I mean, I didn't see the reports about the guy, but certainly there's a lot of people that have gone straight and they dried out and on. They ain't getting no pardon.
Well, comparatively,
from the governor.
There's other things to be upset still about
Schneider. But this guy probably is somebody that Snyder knew personally, or
I believe
friends
so.
who recommended it.
They were both CPAs, right?
Yeah.
I believe so.
This is hooking up a buddy.
Hooking up a buddy.
Big time.
Hooking it up!
After having a really bad record.
Yeah.
Mm-hmm.
You know who I bet has an opinion?
Don't worry. When Dana leaves office, she'll pardon you, Jim.
Rick Thompson. I bet he has an opinion.
Yeah,
on
what's
all
going
this.
on with Rick? We haven't heard from him in a while.
Some news that we could then, and you can stick around, Tim. We could then comment
Rick,
on.
The most patient.
Yeah, you muted me, so you didn't hear from me at all.
You're totally the most
I'm
patient.
sure Rick was just going off.
100%
great
Jim.
shit. We just didn't get a chance to hear it.
100% Jim Powers, not me. Jim Powers, 100% on that.
He was messing with you, Rick.
I was not. I was not.
Mm-hmm.
No, but the fact is, when we're talking about a per se driving limit, we have to remember that society demands what they demand. And even though we know that sometimes what they want is not realistic or it's not appropriate, society needs a number. And they need to be, Gretchen Whitmer has said several times she's going to make the roads safer. She's already taken some measures to accomplish that. This is just going to be part of the overall scheme. And it is a bitter pill that we're just going to have to swallow. Tim Beck said it. It's coming. You just have to be ready for it. And the fact is we can argue, and we should.
If they do come up with a number,
we should argue.
They might not. We'll say, prove it. Yeah. How do you come up with
We'll
that?
show them Jamie. They'll drain Jamie's blood. It's going to be 100% Simpson oil.
And I'll be driving perfectly.
He'll be driving perfectly.
On a higher plane.
Exactly.
Yeah. Keep in mind. Here's a little factoid. Here's a factoid that I think some of you, Rick, I'm sure you know this, but the creation of this whole committee that Margot was on is the creation of Senator Lucido. Yeah, Frank Lucido, that's his creation. And Chuck Ream and I were at that, hearing with Jones and, stuff like that. And we talked and, I gave some input and everything like that. And he's doing this study. And I talked to Frank Lucido afterward. Oh, he was pretty, kind of vehement that he was adamant that we are going to get to the bottom of this. We need to have a scientific study. We need to have the best minds, and so forth. And we're going to find a solution, darn it. That was his pitch. And Jones agreed with that also. And so I think, again, where this is all leading is ultimately to some, 0.05 or whatever the hell.
Yeah.
I'm just saying.
You're right.
That some
0.0 going to jail.
But if we could get it to like Colorado, that would be helpful.
Well, if you can get it to where if you can get it to where it's not a crime in and of itself, right? That they still have to prove impairment. So it's not strict liability. Then you've done everything that you can probably do.
But it will be a crime. That's not what.
Well,
Otherwise,
it could be presumption of a crime.
Yeah. Why would they even be testing him?
It'd be presumption of a crime, but it's not in and of.
Well, I think we're all in agreement.
If
there has to be a number, we try to get it as high as it can. Otherwise, we try to challenge why a number would be selected.
We're still all fucked in this room, all right?
Let me just point out, though, that it is, as Tim mentions, the creation of this particular panel was done by the legislature, and their mandate is, it states right in their purpose, is to come up with a driving limit, a nanogram driving limit. This is why they were formed. not to explore the issue or decide whether one was appropriate.
So their mandate
is to come up with a number.
Sure.
That's what the legislature commanded them to do. So for them to do so isn't a betrayal. It's just them following what the legislature gave them as a job.
It's still very appropriate.
You may know better than me, Rick.
It's still very appropriate
I'm not arguing with you.
To say that they cannot.
I'm just saying, but.
It's still very appropriate for them to say we can't come up with a number, no matter if they were mandated to go find a number or not. They can say we don't have the science.
Fuck your number.
It's a hung jury.
Thank you.
Yeah, I agree. I think you're right, and I wish they would have the boldness to do that. I doubt that they will.
I thought I heard that they made a recommendation. They said come back with another one. It sounds like the Schaefer report.
Huh.
No, didn't you get the memo? We need a number. Right? It's like, hey, here's a report we came back with. Don't make it illegal. They're like, too bad. We got to get a number.
You know, I mean, here's the thing. Doing the wrong thing right is not a substitute for doing the right thing. So the right thing is to say there's no science behind it.
Leaving it where the police have to see the driver go over the line 3 times or drive too fast or too slow or whatever it is.
Impairment is the...
And then pull the person over and see what's going on. That's leave it as it is.
I mean, if it has to be, let them... If they draw blood, it gets to that, and that's the purpose of the rest. They got probable cause. They think they're... And let the number, whatever, is come into evidence, and they can argue about it whatever they want, but... Right? But it's certainly not as...
It's the same way they do it for prescription drugs. I mean, they don't have these per se limits.
You're absolutely right. Drugs. It is an absolute... And they don't like prosecuting those. Because there's no number.
Right. You gotta prove impairment.
And most of the time, it's therapeutic levels by the prescriber.
Well, and you can never pass arbitrary and capricious rules. I mean, that is the essence of due process. So it's still subject to challenge, not only on due process grounds, but on Daubert, reliability, methodology, science. There's no science behind it.
In the sake of Machiavelli and my dear friend Tim Beck, let me say the following. To Representative Lucido, who I see eye to eye on a lot of things, he's a champion of the forfeiture. Look what's going to happen. They're going to pass some kind of... You got to be convicted first. We did it to dance up there and got killed. Like they were attacking us. I brought some clients up there. They were brutal to us. But I would say, like, look, and if you're looking for evidence to get to the bottom of it, we have had, by virtue of a unanimous opinion in People versus Kuhn by the Michigan Supreme Court, that said, on this issue, we're going to take a group of people who arguably, because their patients are sick from generally, are potentially worse drivers, just because they're, they have an illness, right? It's some serious debilitating. But they're driving anyways, and we're going to let them use cannabis, and we're going to remove them from the zero tolerance law and force the government to prove impairment and some associated effectuation of the cannabis use medicinally with the driving.
Yeah.
And what do we have?
Mike,
What do we have? We have 300,000 people. Show me where we can identify the disaster that's taken place. If it existed as a real concern, this little pilot study of letting these individuals drive with cannabis in their system and that not being the crime, but have to find them driving around badly, the test's over.
Right.
To my friend Representative Lucido, in the sake of Machiavelli, I asked for that.
Well, here's the thing, though, Michael, and this may be an esoteric legal nuance, but I think, maybe wrong, but I think the Supreme Court ruled in the Kuhn decision that because the way the MMMA was constructed, that it gave protection to medical marijuana patients from per se laws. Now, again, I think, and if you take that to the next level, that means that, the legislature could amend the Michigan medical marijuana, law and institute, some special standard. See, that's my take on that one. And the legislature has not done that. So that Supreme Court ruling stands. And we have the same language written in to Prop 1.
And I would add to that,
exactly
Tim, just
the same thing.
And I would add just another point, which is a really important aspect of the MMA, which you would think if across the board had been utilized, but the conflict of law resolution, Chapter 7, that says any law that conflicts with the MMA, that's where they drew the strength to say, not the public health code, because we're in the traffic code. Public health code is the dominant beast of all beasts. The traffic code conflicted with the MMA, specifically in Section 7 where they said a person, what you cannot do, a person may not drive, operate a motor vehicle while
with any detectable.
Under the influence.
Was allowing for internal possession part of that consideration too?
Well, it didn't even address it. They said you can't operate heavy equipment while under the influence. You can't be driving a vehicle when under the influence or whatever the language, if it's impairment or influence, but specifically not the other, which is that if you have it in your system, it's a crime. It authorized the driving with the exception of as if you had a script and it said, drive with caution, right? Take 2 of these and drive with caution or whatever, something like that. I mean, that's the way it was, my interpretation. And the Supreme Court found that, but they did rely heavily on, and Tim, you make a good point, because you didn't hear my rant earlier of there's still people getting sentenced in court to misdemeanors, put on probation for misdemeanors, but today the law is a civil infraction. I heard judges not allowing people to use marijuana on bond because in referring to it still as any illegal substances, as an illegal substance. I made my case that not just the general principles that we're talking here, just basic, a new law that conflicts with another law. How's it resolved? Well, the law specifically says, the new law says, if a law conflicts with this, we win. And there's even better language in Prop 1 because it speaks to the intention of the law in Section 2 to legalize marijuana. And the last section says this law is intended to be read broadly, interpreted broadly, in conformity with Section 2, which is to legalize marijuana. So you have this just bursting at all ends, unequivocalness about what this law is supposed to do and ways to resolve it. So as I stand here, my argument today was putting that aside, because I said as judges 2019 February, does anyone know that marijuana was legal? It's like you can't put people on probation for civil infractions. And the Supreme Court put out a memo about this same issue. But no one's doing anything differently. So, but in addition to that, the punishment here that we're still talking about is as if it's a crime. And likewise, the treatment of it for the driving has this, it carries with it the same lie, the same baggage, the same unwarranted, justifiable negativity. And the argument's beginning there. The argument should really begin with, so what are we going to do about all this terrible shit that the police have been doing and just shit that they've torn up over the years, and all of a sudden it's legal? Like, I'm not asking for reparations, but there should be a point in time where they kind of announce a baptism of some kind, of jumping in the mikvah or something, you know what I mean? Yeah. They kind of convert to a place where they have declared, okay, we're not going to do this anymore. You know what I mean? Maybe that's fantasy.
Here, let me ask you a question. Does anybody, any of you folks, because I don't know the answer to this, what happened after alcohol prohibition was abolished? Was there amnesty?
We were talking about that earlier. Remember, Michael? We were talking about that earlier.
Well, no, Tim, this is what happened. This is the issue, because that question that you asked is exactly where, in addition to this statute, this one's newer. There's got to be some precedent, right? So the area of law that we have discovered is when they changed the sentencing guideline scheme for the mandatory minimums with cocaine cases. At one point, this is the example, this one case that got Fraser reading right now, which is you are convicted, you're charged with the culpable date and the conviction date where they went to trial, pled guilty, was under the law, which is if it was over 225, less than 650, mandatory 10 years. Okay? Now, let's say that you committed the crime or were convicted of that behavior, but now the legislature has amended the law, which they did, to say over 225, less than 650, mandatory 5, and the court has the discretion to deviate from the guidelines if they can find substantial compelling reasons. But it was a change specifically intending something other than mandatory 10 years. So the question before the Supreme Court it went to, in cases Schultz and Sands, question before the Court of Appeals and then later the Supreme Court was, how does the sentencing court treat this particular case? In other words, if someone was charged with a crime today, it'd be a civil infraction. If they were charged